In past videos, I've covered the Arizona Peace Officers Bill of Rights, contained in ARS Section 38-1101, and the following sections after that one. Recently, I've come across a number of agencies that seem to be skirting part of that law. Specifically, today I'm going to discuss Section 1104, which is the section that talks about the specific protections that officers under serious investigation have. If you are either faced with an internal interview yourself, or if you're representing an officer under investigation, I recommend that you read and review this section of the law prior to the interview. I'm Steve Serbalik, and I'm a panel attorney for AZCOPS in Arizona. Before I get into the specifics of 1104, know that last year, AZCOPS championed a bill, and Governor Ducey signed a law making it clear that all agencies must follow the Peace Officers Bill of Rights, whether or not the agency has an MOU or other labor agreement. So 1104 applies to all local law enforcement agencies, whether they are cities, towns, or counties. The most important part of 1104, in my opinion, is found in A2, which defines what agencies must provide to officers prior to conducting an internal affairs interview involving an allegation that the agency of the officer reasonably believes could result in a suspension, demotion, or termination. For these interviews, prior to the interview, agencies must provide a notice of investigation to the officer, and the NOI must also provide some specific information. The NOI can't just contain a list of policies that are alleged to have been violated. The NOI must also contain all known allegations of misconduct that are the reason for the interview. For example, if an NOI alleges that an officer was unprofessional and cites the agency's unprofessional conduct policy, it must also contain specific allegations of misconduct that inform the officer as to what he or she specifically did to be unprofessional. ARS Section 38-1104 also requires that, along with the notice, the agency shall provide any relevant and readily available materials, along with the complaint leading to the interview. But agencies may choose not to disclose the complaint itself if the complaint alleges unlawful discrimination, harassment or retaliation, or complaints that allege violations of federal EEOC matters. So although agencies can and have argued that they are withholding certain complaints from disclosure prior to an interview, nothing in this statute allows an agency to withhold the allegations of misconduct that are the reason for the interview. And nothing in this statute allows the agency to withhold other relevant and readily available materials besides the complaint itself. The last sentence of A2 makes it clear that the format of relevant and readily available materials may be written, audio, or video. Now there's one exception to the disclosure requirement that I just discussed, but its use is really rare. ARS Section 38-1104 B2 says that agencies do not need to disclose any fact to the law enforcement officer that would impede the investigation. The way I read B2, this applies to situations where the agency has reason to believe that the officer or representative is being dishonest or has a history of lying to or misleading investigators. It's not a blanket exception to get around the clear intention of the legislature to prevent officers from being ambushed in interviews. Also, the Peace Officers Bill of Rights applies to any investigation of law enforcement officers by agencies, whether the investigation is being conducted by internal affairs, human resources, or an outside investigator that could be hired by an agency. But it does not apply to criminal investigations or investigations being conducted for non-disciplinary purposes. For example, it wouldn't apply to civil litigation or state EEO investigations. These topics are complicated, and if you feel like your agency is not complying with or will not comply with the law, ask for help. Lawyers like me and organizations like AZCOPS are here to help ensure that agencies follow the law and provide due process protections to law enforcement officers. Finally, I know that there may be some people who believe these protections go too far, but remember, officers facing internal affairs investigations have a lot on the line. They don't have the right to remain silent. And if the officer creates an integrity violation unintentionally by not remembering something correctly, that officer is facing not only the loss of a job, but possibly the loss of their career. The provisions contained in this law simply make it clear that officer interviews shouldn't be memory contests, and officers should have the opportunity to review relevant and readily available materials to make sure that they can adequately address the allegations against them during their interviews. As always, don't forget to like this video and subscribe and turn on notifications. It really helps out the channel and helps other officers see the content. Be on the lookout for future videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Cerbalic. Thanks for watching and stay safe out there.